Good morning. The Public Safety Policy Conference Committee will come to order. Today is May 8th, 2026, and we do have a quorum present that consists of, well, all members of the conference committee from both sides are present and in the room. Just going to make a couple of prefatory announcements here. One is, and I don't know what the House has been doing about this, but in terms of the Senate, we've been making announcements with regard to decorum and safety for everyone in the room. By attending this hearing, you agree to adhere to the standard expectations and decorum of the committee as explained in the written document available with committee handouts. There should be one in the back of the room, as there has been all for Senate hearings. And any additional verbal instructions I may add as chair. So we will expect everyone to be respectful in their as they're sitting in their chairs, if there's any testimony for that as well, and we reserve the right, if there are disturbances, to have people removed from the hearing room. We have a lot of items on our agenda. This is a policy-only public safety bill. There'll be separate conference committee for the public safety and judiciary budget bill. Anything with money attached is not in today's consideration or on the agenda. So what we're going to do is we're going to work as closely as we can to the side-by-sides. We have an agenda that goes through each of the different policy proposals. The plan is to adopt either House or Senate language as we're going through it. Members, on your agenda, you will also see there are amendments that have been prepared and anticipated, and there have been some conversations prior to this morning's hearing to discuss how to resolve some of the areas where the House and the Senate did not have agreement. The amendments are going to be coming, but they're not going to be adopted in the first run-through of all these provisions. So if you see things as we're adopting them that don't quite match up with what you're hoping for, please wait until we get to the amendments on each of these areas so that before you'll understand what the full picture will be, and we'll have conversation at that point. We did publish the data or the notice for this hearing today. There was an opportunity for those, if anyone wanted to sign up to testify publicly at the hearing. As of this morning, the deadline was 7 p.m. last night. No one signed up to testify. Just so you know, there was an opportunity. Also, we are not expecting to take testimony on any issues or items that are not present coming in from either side. So if it didn't come in from the Senate, didn't come in from the House, there may be one exception, I think, for a bill that was traveling somewhere else or separately, but that's the basic ground rules here. So with that said, and to adopt provisions, we need a majority of each body's conferees. So that means on the House side, 3 out of the 4 conferees will need to support adopting for that to happen, and separately, 2 out of 3 on the Senate side will need to adopt or vote to adopt the provision. If it doesn't happen on either the House side or the Senate side, the provision cannot be adopted. Before we go any further, I do want to take just a brief moment to allow each of our members to introduce themselves. We have a number of them are retiring at the end of this legislative session. We are enormously grateful for their service and their contribution to the legislature, and in particular to the space that we're working in today to public safety for our communities. So I think maybe I will first turn to my right, and Chair Novotny, why don't you start?
Well, as you stated, Chair, my name is Paul Novotny. I'm this representative for and co-chair for public safety, and I will be retiring at the end of this session.
Chair Moeller.
Thank you, Mr. Chair. I'm Representative Kelly Moeller, represent 40A, which is the Northern Ramsey County suburbs, co-chair of the Public Safety Committee, and I too will be retiring at the end of this session.
Hi, everyone. Representative Sandra Feist, co-vice chair with Representative Whitty. Have served on the Public Safety and Judiciary Committees all 3 of my terms, and it's been an honor. And I will be retiring at the end of the session as well. Thanks.
Thank you, Chair. Representative Jeff Whitty. I represent 57B, which is Lakeville. I'm a vice chair of public safety, and I think I'm the reason they're all retiring. I do feel bad about that, but I will be returning hopefully next year. Thank you.
And to my left, Senator Umu Verbatim.
Good morning. I'm Senator Claire Umu Verbatim. I serve as the vice chair of the Senate Judiciary and Public Safety Committee. Hopefully, I'll be coming back.
Senator Limmer.
I'm Warren Limmer. I'm state senator from Hennepin County, western Hennepin cities, as well as Maple Grove. I, too, will be retiring, not at the end of this session, but the end of the year. But this is my last session. I'm right now the ranking member on the Senate Judiciary Committee.
And Senator Limmer and I have traded gavels back and forth as chair of our Judiciary and Public Safety Committees as the majorities in the Senate have shifted, so.
It's been a good tag team.
It has
Mr.
indeed.
Chair.
All right, well, again, thank you. An enormous amount of talent and experience and knowledge retiring. And thank everyone for all of the public service that you've done. And I'm not retiring unless my voters decide differently, which is always a possibility in this world, but I hope to return next year. All right, that said, let's dive into the substance of the hearing today. We're going to start with the agenda item relating to identity definition for purposes of identity theft crime. I understand Representative Whitty, we're going to do the House process here, which is to start with a motion, then have discussion, and then vote on adoption. So Representative Whitty, I understand that you are having a motion on this item.
Thank you. I moved adoption of the R1 and R96 through 100, the House language.
Unless there's an amendment.
Member or staff discussion on that.
Okay, this is House provision. Does someone from the House want to tell us what this is, please? Mr. Johnson.
Senators, members, Ben Johnson from House Research. This provision is in both the House and the Senate bills. They differ slightly. These changes, they include changes to the financial and identity theft crimes. It includes authorizing county attorneys and the Attorney General to issue certain administrative subpoenas. It also amends some definitions to account for the use of AI and other technology that's being used to commit identity theft offenses. And it extends the statute of limitations for certain theft and fraud offenses. Mr. Chair, that's a high-level overview of those provisions. They can be found on, as Representative Whitty indicated, R1 and also on R96 through R100. It's the House Sections 1 and then Sections 59, 69, and 82. These will be House lines 6118 to 6312 and also House lines 7521 through 7711. And actually, I missed a chunk, and that's the ones on page R1, and that's House lines 2.2 through House line 4.5.
All right, and we are not anticipating any amendments down the road on these provisions. Is that correct, Mr. Johnson?
Mr. Chair, members, there are no amendments that have been drafted at this point to these
All right.
provisions.
Thank you. So let's open it up for a member discussion. Is there any members of the conference committee that wish to speak to this motion? All right, is there anyone, any member of the public in the room that wishes to be heard on this particular provision? I'm not seeing anyone come forward. So Representative Whitty renews his motion to adopt the language that has been described in this item. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. All right, next item is on supervision abatement status relating to corrections. I understand Chair Novotny has a motion.
That is correct, Chair, and I move this bill from the resolute part from R11, the House language. This is just a transfer of employees for the Department of Corrections to a county bill.
Which, is there a staff member going to describe this? Mr. Diebel.
Excuse me, Mr. Chair and members. This section would direct the Commissioner of Corrections to take into consideration an inmate's ability to, or efforts to complete reimbursement of their restitution requirement prior to giving them supervision abatement. So it's a factor for the Commissioner to consider if they did that in good faith, and affect their ability to pay.
And this is a House-only provision, is that correct, Mr. Diebel?
Yes, Mr. Chair.
Is there any member discussion or questions on this? Senator Limmer.
Thank you, Mr. Chair. I see that the effective date is September 1st. It's usually when we are dealing with criminal matters, it's August 1st. Is there a reason why there's September 1st as the effective date?
Someone from the House want to respond? Mr. Novotny?
Chair Moeller, or Chair Latz.
You know, I've been called a lot of things this legislative session. Without respect to gender, also I've been called, but I haven't been called Chair Moeller this year yet, so.
Get used to it, it's a habit for me.
Yeah, thank you. No, it's another moniker I will wear with pride.
I'll work on it. Senator Limmer, this is just a technicality thing that's being taken care of with the Department of Corrections. The Deputy Commissioner's been working on this, and this is just a matter of how the paperwork's done and how that's administrated.
Okay. Good enough.
They are, and she is here to testify if you have any questions.
Ms. Khan, come on forward.
Chair Latz and Senator Limmer, it's a great question. The policy for supervision abatement does not go into effect until September 1st, so we wanted to match the law going into effect with the policy.
Thank you.
Thank you. Any further questions from members or discussion from members of the committee? All right, not seeing any. Chair Novotny renews his motion to adopt the House language on page R11. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. Next item deals with unintentional murder in the second degree offense modifications relating to violations of protective orders. Representative Whitty has a motion. Representative Whitty.
Thank you, Chair. I moved adoption of R24, the House language. It's lines 57.28 through 58.15.
And Mr. Johnson to describe.
Chair Latz and members, this is essentially a technical change related to a policy that passed a few years ago that recognized protective orders from other jurisdictions, in particular Canadian protective orders. Under current law, if an offender commits homicide against a victim who has a protective order that's an enhanced penalty. It becomes a second-degree intentional murder, and this would just indicate that those orders for protection could also be issued in other jurisdictions, including Canadian orders for protections.
Are there any questions or discussion from members of the conference committee on this matter? Anyone in the audience that wishes to be heard on this? Not seeing anyone come forward. Representative Whitty renews his motion to adopt the House language on R24 as described. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment, or the language is adopted. Next item addresses prediction markets. I understand Chair Novotny has a motion.
That is my motion. I move that the lines R25 through R28 of the House language be added to the bill.
Mr. Johnson.
Mr. Chair and members, this is the provision related to prediction markets. As a brief reminder, prediction markets are an opportunity for individuals to purchase futures securities based on the outcome of certain events, particularly sports events. This provision would ban the operation of those and the advertisement of those within the state of Minnesota, and also put certain limitations on other businesses that intentionally support those businesses. There was a decision by the conference committee previously to adopt the Senate language on this. The language is extremely similar, but there's a provision in the Senate bill that would authorize Alcohol Gambling Enforcement Division to issue cease and desist notices. And there are a few very minor technical changes that the Senate made on the floor. There is an A17 amendment that was prepared for this purpose.
Okay, so members anticipating there will be an A17 amendment on this topic after we finish adopting provisions. Any discussion from members on this matter? Is there any member of the public in the room that wishes to speak on this item? Not seeing any hands raised. So Chair Novotny renews his motion to adopt the House language on R25 to 28 relating to this topic. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. Next item has to do with judge requirement to inquire whether the victim's been notified of plea and sentencing hearings in compliance with the victim notification requirements. Senator Uma Verbetten has a motion.
Thank you, Mr. Chair. I'd move adoption of R30 through 34, the Senate language.
And who's describing the language?
I can.
Oh, Chair. Senator Uma Verbetten, go ahead and describe it.
Council can certainly give a more detailed explanation, but this was Senate File 3871. It was a agency bill from Office of Justice Programs, just making some changes to ensure that victims are notified of plea hearings, sentencing hearings, protecting their identities in certain prosecutor petition documents, and then requiring that victims be notified if an offense is eligible for automatic expungement.
Mr. Backus, anything to add?
Mr. Chair, members, no, just that the House and Senate has identical language in this article.
Any discussion or questions from members of the conference committee? I know that a lot of judges in Hennepin County have been doing this for a while, so I think bench policy has gotten ahead of the statutory requirements here. Anyone in the audience that wishes to be heard on this? Not seeing anyone. All right, Senator Uma Verbetten renews her motion to adopt the Senate language on R30 to 34, the side-by-side. All those in favor say aye. 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 Opposed? Motion prevails. The language is adopted. Next item on research data protection provision for individual data. Senator Uma Verbetten has a motion.
Thank you, Mr. Chair. I move adoption of R3 through 29, the Senate language. This is also another agency bill from Office of Justice Programs to classify the research data on individuals as private data. That was Senate File 3872.
And who's going to describe? Mr. Backus? Ms. Primo? Mr. Backus?
Mr. Chair, this is the Senate Article 1. Basically, these are just a bunch of mostly technical changes to the DPS statutes suggested by the department. The House and Senate have identical language here.
Is there any discussion from members of the committee? Anyone in the audience wish to speak on this? I see no one coming forward. Senator Umu Verbetten renews her motion. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. Next item, ignition interlock program license revocation requirements modifications. Senator Limmer has a motion.
Thank you, Mr. Chair. I certainly will move the motion. I must have missed the memo. I wasn't prepared for this particular amendment. So I'll have counsel make the presentation.
Mr. Chair, members, this is
Mr. Backus.
This is Senate Article 3, which begins on page R34. It's entitled Impaired Driving Driver's Licenses. These sections, all but one, were proposed by the Department of Public Safety. There's one section, Section 6, that's a Senate-only, that lengthens the time that a temporary driver's license issued at the scene of a DWI is effective, consistent with changes we made last year. The side-by-side doesn't indicate this, but the House has passed a standalone bill containing identical provisions with the exception of that provision. And then also the Senate has a Senate Section 2, which has to do with the B card, which is a no alcohol restriction on a person's driver's license and would extend the period that a person would have to wait before they can get that removed. My understanding is that the motion would be to accept the Senate language with the exception of Section 2, which is that B card provision.
Senator Limmer.
At some time, I want to make the formal motion
Of
in
course.
its completed form.
Sure.
I don't know if we're ready for that yet.
Not quite. All right. So if we adopt this motion, then the Senate language with regard to extending the B card requirement will not be adopted and will not be a change in the law. It will remain at 10 years instead of being extended to 20. Is that correct, Mr. Backus?
Mr. Chair, members, that's my understanding of what the motion is supposed to be, yes?
Yes. Okay. Mr. Johnson, you're nodding your head. You agree? Well, this is my bill, so I understand and I agree with the proposed resolution here as well. Any discussion from members? Anyone in the audience wish to be heard on this? Not seeing anyone come forward. Senator Limmer, would you like to renew your motion?
Thank you, Mr. Chair. I don't think ever in my history I've moved your motions before, so this is a first. I move the adoption of the R34 Senate language lines 28.3 through 7 and lines 28.1 or 18 through 32.10. And is that correct, Council? Yes, it is.
All right. On Senator Limmer's motion, historic motion. All those in favor say aye.
Aye.
Opposed? The motion prevails. The language is adopted.
I'm getting soft.
One final piece of collaboration,
Yeah.
Senator Limmer. Might not be the end. We still have some more work to do in the next week. Next item here on the Department of Corrections licensed juvenile and adult community-based residential facilities. Representative Feist.
Yes, thank you, Chair. I move adoption of R42 through 60 Senate language. That is, as you said, the Department of Corrections licensed juvenile and adult community-based residential corrections facilities responsibilities clarification provision. That's a mouthful. What it's doing is giving the Department of Corrections more authority to sanction jails that fail to meet the important standards that were set in the Hardell-Sherrill Act, which passed in 2021. It modernizes and clarifies Minnesota's licensing framework and will create a parallel and consistent licensing structure across facility types. And that's what this language does.
Is there any further description from staff, or that was pretty thorough, Representative Feist? Anything to add from staff? Mr. Diebel? Senator, Mr. Backus?
Yeah, Mr. Chair, nothing that interesting to add, just to point out that the House and Senate have identical provisions here. If you look at the side-by-side, the repealers look like they don't match, but they actually do. So these are identical provisions.
Any,
And Mr. Chair, I know
Mr.
there's an amendment that I believe you want to take at the end of this process that the Department of Corrections has suggested. I believe it's the 830.
right. Okay, we will get to that. Any discussion from members of the committee on this motion at this time? Representative Feist.
Thank you, Mr. Chair. I just wanted to mention that I think this is really important, and I would like to see something similar on secure DHS licensed facilities. On April 28th, there was a report of a really horrific incident involving a 13-year-old child and a staff member at one of the DHS licensed secure facilities, and I believe that that facility had a $1,000 fine and no corrective action recommended. So that is not enough to protect people who are in secure facilities in Minnesota. So I'm glad we're taking this step. I hope the folks in the DHS space are doing the same. Thank you.
Any further discussion? Anyone in the audience wish to speak on this matter? Not seeing anyone come forward. So Representative Feist renews her motion to adopt this language. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. Next item, criminal conviction, employment, or occupation provisions modifications. Chair Novotny has a motion.
Chair Latz, I move to adopt House language R65 through 67, lines 50.12 through 52.15.
For description. Ms. Primo.
Mr. Chair and members, the language on R65 to R67 is similar in both bodies. The House language amends the law related to government employment of individuals convicted of a crime in response to a Court of Appeals decision. The changes clarify that a person must show rehabilitation by completing a criminal sentence and also show present fitness for the specific position. The House language is on lines 50.12 to 52.5.
And Ms. Primo, I know there was a court case in this area, and we've received some communications. What is the effect then of adopting the House language on the state of the current law?
The Court of Appeals decision merged those two requirements. So this, by adopting this provision, it clearly requires that both of those provisions need to be shown, and it permits the licensing or employment authority to be able to disqualify someone from employment even if those provisions are shown. And it adds in additional evidentiary requirements as well in the House language.
So does that effectively restore the understanding of the law as it was prior to the Court of Appeals decision, or does it kind of do a couple of things? It restores part of it, but it does allow for the further look back if there are certain evidentiary standards met? Or, Ms. Primo.
Mr. Chair and members, it does a little more than just that. It was the later description that you provided. it supersedes the interpretation that is in the Court of Appeals decision. I'm not sure what the employment and licensing authorities were doing before that. Minute did challenge, Minute was the party that was in that court decision, and they clearly had a different interpretation that existed prior to the Court of Appeals decision. However, the Court of Appeals did not agree with Minute's description of interpretation of the law.
Any member discussion on this provision? Is there anyone in the room that wishes to testify or speak in connection with it? Not seeing anyone come forward. All right, Chair Novotny renews his motion to adopt the House language on R 65 to 67. All those in favor say aye.
Aye.
Opposed? The motion prevails. The language is adopted. All right, next item on unemployment insurance judges and paid leave judges. Senator Umu Verbitten has a motion.
Mr. Chair, I move adoption of R 67 through 68, the Senate language.
Ms. Primo.
Mr. Chair and members, this is a Senate-only provision, and this extends judicial data privacy protections to current and retired judges and current employees with Indeed's unemployment insurance and paid leave appeals divisions, but exempts them from the real property protections.
All right. Is there any discussion from members of the committee on this proposal? Anyone in the audience wish to be heard on it? Not seeing anyone. Well, Senator Umu Verbitten renews her motion to adopt the Senate language on R 67 and 68. All those in favor say aye. Aye. Opposed? Motion prevails. The language is adopted. Next item, medications for persons detained in jails. Representative Whitty has a motion.
Thank you, Chair. I move the adoption of R 70 through 71, the House language. It's on lines 32.14 through 33.17. This is on the jailhouse medication, making a change.
Description, Mr. Diebel.
Mr. Chair and members, this is a modification of a law that was enacted last year to set up standards for jails to provide prescription medications to those who are incarcerated or detained at their facilities. The jails found the statute to be cumbersome, so they asked for some modifications, and so the stakeholders worked to give them some flexibility to administer the provisions and meet the intent of the law, and all have agreed to it, and the provisions are identical in both the House and the Senate.
Any discussion from members of the committee? Chair Moeller.
Thank you, Mr. Chair. And I just want to say, too, every time we talk about this bill, there was a lawsuit that surprised us that was filed after these provisions passed last year. And by making these changes, this is part of the normal process of legislating where we often come back for clarity's sake, and we are not admitting that there was anything wrong with the bill and the language that we passed last year. So if anyone is listening for purposes of the lawsuit, I just wanted to make that clear on the record. Thank you, Mr. Chair.
Representative Whitty.
Thank you, Chair Latz and Chair Mueller for that. My question to House staff is, when will this go into effect that maybe help this along? Is it on the adoption of the law? I don't see a date in here. That's why I was curious.
Mr. Diebel.
Mr. Chair and Representative Whitty, it should be July 1st unless we prescribe a different effective date. Sorry,
Diebel.
August 1st. Sorry, my apologies.
August 1st?
Yeah.
Anyone in the audience wish to be heard on this? Any further discussion? Representative Whitty renews his motion to adopt the House language on R 70 and 71. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. Next item, domestic abuse definition and provisions modifications. Chair Moeller has a motion.
Thank you, Mr. Chair. I move adoption of R 72 to 78, the House language. I'll note that there is an A15 amendment that is coming later. The language in the House and the Senate is the same, except I think one of us uses numbers and the other one uses Roman numerals. But the
That
provisions.
says so much about the difference between the two bodies.
And actually, I can turn it over to staff to describe what it does. Thanks.
Mr. Johnson.
Mr. Chair, members, these provisions make a variety of changes related to domestic violence laws. At a high level, they require some additional reporting by law enforcement agencies. It also amends the definition of domestic abuse case for the purposes of the policies and procedures that prosecuting offices have to adopt. It extends the time during which law enforcement can make a warrantless arrest for a misdemeanor domestic assault offense. Currently, it is limited to 72 hours after that offense. This would extend it to 14 days. I'll note that that 14 days is part of the proposed A15 amendment. The current language in the bill says 28 days. It also clarifies requirements related to holding or releasing individuals who are who are arrested for those domestic violence offenses, including adding some cross-references to existing laws so that it's clear what covers and what applies and where county sheriffs need to look, and also provides them with some additional guidance for factors to consider in making those decisions.
I will note for the record, and contrary to expectation, it is the House that is using Roman numerals. Any further discussion or any discussion from members of the committee? Anyone in the audience wish to be heard on this? I know there's been some conversation among stakeholders on these issues and the amendment which has been posted. I think we'll be addressing that, so we'll get to that. At this time, then, Chair Moeller renews her motion to adopt the House language on R 72 to 78. All those in favor say aye. Aye. Opposed? Motion prevails. The language is adopted. Next item, time extension for certain grant use. Representative Feist has a motion.
Thank you, Mr. Chair. I move adoption of R81 to 90 in the House language, and I have some editorial comments, but I will wait for that point in this process. That is my motion.
All right. Staff to describe it. Mr. John. Or Representative Feist, if you wish to.
Sorry, I should describe it.
Representative Feist.
Yeah, so I guess this is part of my editorial comments. I'll explain what it is. So this was grants that we created in 2023 for dual status or crossover youth. This is children who are or are at risk of being involved simultaneously in the juvenile justice and the child welfare systems. Experts came to us and said that this was an important area of investment to address the needs of these really complicated children. And we allocated $2 million towards that, and I found out that we didn't spend $1 million that we had passed into law, and that really frustrates me because we know that these kids need help, that this is a public safety issue, that this is a child welfare issue, and so that was super frustrating. The money that was spent in part was allocated to Ramsey County, but in the RFP process and the grant approval, they gave them through December 15th, 2026 to spend the money. And then they found out at the last minute that they were told they had to spend it by like June of this year. And so all this amendment actually does is extend the ability of Ramsey County to invest these dollars in these children through December 15th, 2026. And so that is why I make this motion. Thank you.
And I understand the Senate has the same language, correct? Mr. Johnson? House and Senate the same on this?
Mr. Chair, the House and Senate language is identical. I'll add one brief thing. This does not extend the ability for anyone to apply for these grants. This covers grants that have already been issued and the money has already been encumbered. But by law, the money cancels even if it's encumbered a year after it would have canceled previously. And so the money is scheduled to cancel on June 30th, despite the fact that the grant has been issued, and the grant period for that money that has been issued runs all the way until December. So this does not extend the ability to apply for those grants or create new money. It just allows the already encumbered money to continue to be used until the end of that grant period.
Any discussion from members of the committee? Anyone in the audience wish to be heard on? Not seeing anyone come forward. Representative Feist renews her motion to adopt the House language on R 81 to 90. All those in favor say aye. Aye. Opposed? Motion prevails. The language is adopted. All right, next item relating to victims of domestic violence petitions. Senator Uma Verbet has a motion.
Mr. Chair, I move adoption of R 90 through 96, the Senate language.
All right, who's going to? Staff points out to me that this is my bill also, so thank you, Senator Uma Verbet. Ms. Primo.
Mr. Chair and members, this is a Senate-only provision, and it permits parties who are protected by an order for protection to petition the court for an additional order that requires a wireless telecommunications service provider to transfer billing authority and the rights to a wireless telephone number to the petitioner or some other designated person, or remove or release the petitioner from a shared wireless plan and assign a substitute telephone number.
Any discussion from members of the committee? Anyone from the audience wish to be heard on it? Yes, we have a couple people stepping forward. Come on forward and identify yourselves, please.
Good morning, Mr. Chairman.
Mr. Carlson, go ahead and identify yourself for the record and present your testimony.
Thank you, Mr. Chairman and members. Joel Carlson. I represent violence-free Minnesota and absolutely support this provision in the Senate side. But I would like to make a couple comments, and we may need a little bit more time to make this work. And the reason that I say that is we have a federal law in this space that is slightly different than the Senate language, and from a victim's perspective might be a little bit more protective for the victim. As an example, the federal law allows you to get a affidavit from your physician that you have been an abuse victim to separate from your wireless carrier. The state provision doesn't provide that requirement, and that may be easier than getting an order for protection to separate from your wireless provider. And as we all know, our cell phones, which we carry everywhere, are critically important. So we absolutely support having a state remedy and having a state protection for this, but we would want to make sure that we're consistent with the federal law so that wireless providers don't have an ability to not do what we have the authority to do under the federal act. So it's a yes, we absolutely support, but we'd like to make sure that it's consistent with federal law so that we don't have a differentiation for the wireless carriers to say they don't have to do something in Minnesota because the law is different.
Mr. Carlson, do you have a proposed solution to that?
Mr. Chairman, it would take us a little bit of time to make sure that the two are consistent, but that would be our suggestion, is that we mirror the the state remedy and the federal law. So adding 2 or 3 different provisions to this Senate provision would take us a little bit of time to do, but that would be our recommendation.
Well, we are at the conference committee provision today, anticipating wrapping this up today, so a little late in the process now to do much additions unless there's some other vehicle down the road, if there is consensus for a different vehicle to be used. Or if it's ready and before we wrap up. So I guess we'll take Mr. Carlson.
And, Mr. Chair and members, I will say, with the federal law that's been in place since 2022, we haven't had a problem with utilizing the federal law to make the separation on the wireless account. So it is working, and so our only concern is having a differentiation between the two. And I was there with you at, 10 to 10 when we heard this in Senate Judiciary Committee, and it didn't move in the House. And so I'm just digging into this now as it becomes in front of the conference committee to make sure that we're consistent between the two.
Yeah,
Thank
fair
you.
enough. Mr. Carlson, in your assessment, if the federal government passes an additional provision that does not conflict with Minnesota statute, would the federal remedy still be available to implement?
In fact,
independently of what Minnesota statute says?
Mr. Chairman, absolutely. And in fact, federal law has a provision to allow for more restrictive state provisions, but if they are less restrictive, the federal law would apply. Our only concern would be that there's a difference among the wireless providers that think, it'd be difficult for a victim to argue, hey, here's my affidavit from a medical provider that I'm an abuse victim and I can separate from my wireless account and have the wireless provider in Minnesota say that's not part of the Minnesota law. That's the only, and you have to argue with them while you're trying to get through this process. That's our only concern.
So it'd be better to harmonize the two, but
Yes,
if we aren't able to get that done, I would anticipate federal law would prevail
correct.
just under
Yes.
principles of federalism. So,
Yep.
all right, Ms. Pisak.
Hi, thank you. Sarah Pasick. I represent the wireless companies, CTIA, which represents all wireless providers. We also support the concept 100% and have been working with the federal Safe Connections Act, which has been in place. The feedback I've gotten just recently is that the federal law is more generous to victims of domestic violence with the different affidavits and different methods that can be provided to the wireless companies, either at the store or anywhere, are less restrictive in the federal law, and they view the federal law as more generous to domestic violence victims. So we don't want to have confusion between the two laws. The federal law does reference state protections and says that the federal law won't affect state laws or restrictions for survivors that has less stringent requirements for providing evidence of a covered act under the subdivision. So I think there is a little confusion about if the state has more restrictive, do the federal less restrictive, which one must the wireless providers follow in Minnesota? So that's kind of where we're at today.
All right, well, as far as I'm concerned, if we have an amendment or language to consider while we are still meeting this morning, we can certainly discuss how we'd like to handle that. But without any specific language proposal in front of us, I'd anticipate we're going to move forward as it is, and if it doesn't become part of this and there's some other language that gets dealt with in some other vehicle or bill that's moving, then the members can consider it in due course. But thank you for bringing the issue forward to us.
Thank you, Mr. Chair.
I know stuff's moving quickly and coordinating
Right.
stuff is often hard to keep up with everything that's going on. So we'll try to address what we can, but we got to keep our process moving here today, too.
Absolutely.
Thank you.
All right, thank you. Anyone else in the room wish to be heard on this? Any discussion from members of the committee on this testimony or on the motion itself? All right, not seeing any. Senator Uma Verbetten renews her motion to adopt the Senate language on R 90 to 96. All those in favor say aye. Opposed? Motion prevails, the language is adopted. Next item. Notifying petitioner about service of an HRO. Senator Uma Verbetten. Senator Uma Verbetten on notification of petitioner's requirement on service of an HRO.
Mr. Chair, I move adoption of the R96 Senate language.
For description, Ms. Primo.
Mr. Chair and members, this provision is a Senate-only provision, and it requires notice to the petitioner regarding service on their respondent at least 24 hours before the respondent is served. There is an amendment to this that I believe is being addressed at a later point.
Is there any discussion from members? Anyone in the room wish to be heard on this? It is the 831 amendment that will be coming on this item as well. Senator Uma Verbetten renews her motion to adopt R96 Senate language. All those in favor say aye.
Aye.
Opposed? Motion prevails, the language is adopted. All right, next item, age deception cases, criminal sentencing modification. Senator Uma Verbetten.
Mr. Chair, I move adoption of R100 through 103 Senate language.
Counsel for a description. Mr. Johnson.
Mr. Chair, members, this is a Senate-only provision, but I've agreed to walk through it. It was also in House File 4578. This is a provision that would establish that it's an aggravating factor that would justify a departure from a presumptive sentence if an offender intentionally deceives a minor victim into believing that the offender is also a minor in order to facilitate the commission of a crime. This does not create a new crime by itself, but it would allow a judge to determine that that act justifies imposing a more significant sentence, a longer sentence in most cases, if those factors existed.
Any discussion or questions from members? Representative Feist.
Thank you, Mr. Chair. I'll just mention that we didn't hear that in the House, this bill, and I was like, that seems random. And so I thought I'd share what I learned, which is that this related to a specific incident where an adult posed as a student. And so I support this provision. Thank you.
Any further discussion? Anyone in the room wish to be heard? Senator Uma Verbetten renews her motion to adopt the Senate language on R 100 to 103. All those in favor say aye. Aye. Opposed? Motion prevails. The language is adopted. Next item relating to the BCA background checks. Senator Limmer.
I move the adoption of R 103 Senate language.
Counsel for a description. Mr. Johnson.
Mr. Chair, members, this provision relates to background checks. At the moment, there are a variety of state agencies that are allowed to ask the Bureau of Criminal Apprehension to perform background checks for them. It includes agencies like the Department of Revenue, Department of Children, Youth, and Families, Department of Minute, the Attorney General, and a few others. This would add to that list to include the Office of Legislative Auditor, which would allow the OLA to also request background checks from the BCA.
Any questions or discussion from members of the committee? Anyone in the room wish to be heard on this? Not seeing any. Senator Limmer renews his motion to adopt the Senate language on R103.
So moved.
All those in favor say aye. Aye. Opposed? The motion prevails. The language is adopted. Next item, appropriation for OHE, or to OHE for police training. Representative Whitty.
Thank you, Chair Latz. I moved adoption of the R12 through R13 in the House language. It is lines 15 through 25 through 17.28. It's just use of force funding extension. Thank you.
Yeah. 17.28 or line 17.8?
I'm sorry, 17.28. From 15.25 to 17.28. Sorry for the confusion.
Mr. Chair, just for clarity, it
Sure,
was,
that's right.
Mr. Chair.
Yeah, Chair Muller.
Thank you, Mr. Chair. It's, and just, I think I heard R12 to 13, but just for clarity, it's R112 to R113. Yeah. And the line numbers, I didn't check those yet.
I think it's 17.8. Can council verify? As we get into 17.9 and beyond, we get into Article 2, Public Safety on transfers of motor vehicles and so on. Mr. Diebel?
Mr. Chair and members, the section begins on page R112 of the side-by-side, and it's, as you noted, beginning with line 15.25 on the House side through 17.8 on R113.
Thank you. Just want to make sure we adopt the right language in the motion. All right. Any discussion from members of the committee? Anyone in the audience wish to be heard on? Not seeing any. All right. Representative Whitty renews his motion to adopt the House language on R112 to 113. Lines 15.25 to line 17.8. All those in favor say aye. Aye. Opposed? Motion prevails. The language is adopted. Next item, law enforcement vehicle markings removal. Chair Muller has a motion.
Thank you, Mr. Chair. I move adoption of R114 of the House language. This has to do with decommissioning of police vehicles. It was something that was generated out of the events of June 14th, and I can turn it over to nonpartisan to describe it.
Mr. Diebel.
Mr. Chair and members, this is a new statutory provision that would require law enforcement agencies, state and local law enforcement agencies, to decommission their vehicles before they are put out into the private market by taking off all the markings that would indicate that it was used for a law enforcement purpose, and it would provide for a civil fine for those who fail to comply with it.
And just to note, this, on the Senate side, this was Senator Hoffman's bill as well. And he has reviewed and agrees with the House language on this. And I think I should note, just to clarify on the motion, I think it goes on to page 115, line 18.18. Is that correct? Mr. Diebel?
Mr. Chair, yes, R115 and runs through, on the House side, through line 18.18.
All right, any discussion from members of the committee? Anyone wish to be heard? Anyone in the room wish to be heard on this? All right, Chair Moeller renews her motion to adopt the House language on R114, starting at line 17.9, and concluding on R115, line 18.18. All those in, no. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. All right, members, next item, paid and part-time on-call firefighter provisions. Representative Whitty has a motion.
Thank you, Chair. I moved to adopt House language R115 through R120, lines 18.19 through 24.2. And that's my motion.
Uh, 24.22, is that what you said?
Yes.
All right, for a description, Mr. Diebel.
Mr. Chair and members, this proposal combines two bills from the House related to public safety officer or survivor disability benefits. It adds part-time and paid on-call firefighters to those who are eligible, and it also creates a list of a protocol and list of cancers that are related to firefighters inherent to the occupation that they serve in and are common to for firefighters to contract, to make sure that those are eligible for the benefits. Those who die from those cancers are eligible for the benefits and their survivors.
And Mr. Diebel, I understand, or staff, I understand that there originally was some concern about a fiscal impact, but that has been resolved for purposes of this biennium anyway. That it's got a zero fiscal impact, which is why it's in this policy bill, right?
Mr. Chair, that's correct. There were some changes made to address the fiscal impact of the bill to make sure that the agencies had sufficient funds to fund these benefits for the survivors.
Any member discussion or questions on this provision? Anyone in the room wish to be heard on? Not seeing anyone come forward. Representative Whitty renews his motion to adopt the House language on R115, starting at line 18.19 through R120, line 24.22. All those in favor say aye. Aye. Opposed? Motion prevails. The language is adopted. Next item, Armor State Funding Task Force. Chair Novotny has a motion.
That's correct, Chair Latz. I move to adopt House language on page R120 through 123, lines 30.17 through 32.32.
For a description, Mr. Johnson.
Mr. Chair, members, this is a task force that's being created to establish a process for transitioning the Allied Radio Matrix for Emergency Response, better known as the ARMOR network, to a statewide and state-funded framework. There is a proposed A16 amendment that I understand you'll be taking up shortly that would add the fire chiefs to the list of participants.
And Mr. Johnson, this will cover both the armor infrastructure and also the mobile communication devices as well. Is that right? As a part of this task force and assessment?
Mr. Chair, I believe they are intending to investigate or to discuss both of those issues, yes.
So as members or others may already know, I've been working for a few years to try to find a funding mechanism to help counties who pay for the mobile communication devices come up with funds, because it's about $250 million unfunded or outlay to modernize all that piece of the equipment. And I'm particularly pleased to see that analysis rolled into this task force, because the department is looking at now having to update the towers and the other infrastructure for the armor system as well. So it's good that it's all be considered together, and hopefully there can be one single long-term funding solution taken care of, so we don't keep getting one-off bills every year from individual legislators proposing to help their own counties, take care of their own mobile infrastructure or mobile device replacements. Any member conversation or discussion on it? Chair Moeller.
Thank you, Mr. Chair, and definitely agree. There needs to be some sustainable funding for this. I know we've had bills on in both bodies to have a phone line surcharge, and we would have used those revenues both for this and for victim services funding, which is another area that could really use some help with a dedicated source of funds. And I know that's not part of this armor bill. And if we get a target, maybe something we discuss later. I know Senator Umover Baton's worked really hard too to come up with some other sources of funding for victim services. We created a whole separate account last year and put a couple of things in there, but they're definitely in a crisis spot too. So hopefully, I won't be here, but hopefully those of you who are can work on both of those issues in the future. Thank you.
Any further discussion? Senator Limmer.
Thank you, Mr. Chair. This has been a really vexing problem in recent years. Well, not just recent years. This has been a perennial issue for quite a long time. I think one of the major elements to not finding a solution is the high cost. And I think that has a lot to do with what I would consider almost a monopoly by a particular manufacturer that seems to have a grip on this type of emergency communication equipment. And I would hope that the task force can get out of that pattern and look at perhaps competitors that might offer a cheaper value, but at a high quality. And I think that's one of the major elements why we are running into such a high expense. And if we're at that point where an entire infrastructure has to be built, now's the time to start considering other competitors. Thank you, Mr. Chair.
Any further member discussion? Chair Novotny.
Chair Latz, piggyback on what Senator Limmer said about the stranglehold that one particular company has, and, do they provide a quality product? Yes. Is there as a single source supplier, extremely expensive? Yes. And I would like to add that I also did have a funding stream that I proposed, but that was turned down because we don't like fireworks in the state, apparently. So.
Boy, I'm just not going to take that any further. Any? Yeah, we had a Senate amendment went on the floor at one point on a bill, and it opened up the door to another amendment related to fireworks, and we had to try to walk that one back before going down that rabbit hole this year. Any further discussion from members? Anyone else in the room, or anyone in the room wish to be heard on the matter? Not seeing anyone, Chair Novotny renews his motion to adopt the House language on R120, starting at line 30.17, through R123, line 32.32. All those in favor say aye. Aye. Opposed? Motion prevails. The language is adopted. All right, next agenda item, members, MnCore contracts with businesses. Senator Limmer has a motion.
Thank you, Mr. Chair. I move the adoption of R 123 through 125 of House language.
For a staff description, Council, Mr. Diebel.
Mr. Chair and members, this is a proposal to reform the MnCore process and how they interact with their private businesses that contract with them. It stems from an OLA report, and it requires the agency and commissioner to accurately account for the cost of providing the venue and the labor rates for the inmates who are providing the labor to the contractor, and then disclose that information in their annual report. This is on the House side, it was carried by Representative Robbins, and on the Senate side, Senator Limmer.
Any member questions or discussion? Anyone in the room wish to be heard in connection with this proposal? All right, Senator Limmer renews his motion to adopt the House language on R123, beginning at line 35.12 through R125, concluding with line 37.21. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. The language is adopted. All right, members, that concludes the side-by-side.
We have one more.
Oh, we got one more, because, yeah, there is more here in the side-by-side. Chair Novotny.
I move to adopt Senate language R69 through 170, lines 66.3 through 67.18. Wright County Probation Working Group.
Mr. Johnson.
Mr. Chair, members, this is a community supervision working group provision. Again, it's on pages R69 and R70. This is Senate language on Senate's lines 66.3 to 67.18. I think it was off of the list that some members are working on. So again, R69 is where it starts. This provision would establish a working group to make recommendations on the statutory changes that would help provide clarity regarding various responsibilities when probation and other supervision delivery systems transition between a county-operated system and a system that is operated by the state. There is an amendment for this. It's the A14 amendment, I believe you'll consider shortly.
And this proposal originally came to us from the Department of Corrections, is that right?
Chair Latz was in agreement.
Chair Novotny?
Chair Latz was in agreement between the working group that was established with Department of Corrections and some of the labor units and some of the counties.
Okay. Terrific. Any discussions from members of the committee? Representative Feist.
Thank you, Chair Latz. I support this, this amendment or addition to the conference committee report. And I just wanted to mention that, you know, we updated the community supervision funding formula in a really important way in 2023, but we did not fully fund it, which is in part what leads to the tensions here as some counties transition between the different types of community supervision. And I just got the number I was looking for. If we were to fully fund the formula, actually, I'm not sure if it's 12.6 million a biennium is what we would need in total or more. I'm just gonna see. More, okay. So we need 12.6 million more per biennium, sorry, to fully fund our community supervision funding formula. And I think that's really important. And I think that would get at some of the underlying tensions that this working group seeks to address. Just wanted to flag that, but I support this amendment. Thank you.
Setting the table for more work next year. Chair Moeller already did as well. Thanks for leaving us with these unfinished tasks. There's always unfinished tasks around here. Any further discussion? Anyone in the room wish to be heard? Don't see anyone coming forward. So Chair Novotny renews his motion to adopt the language on R69, starting at line 66.3 through R70, line 67.18. All those in favor say aye.
Aye.
Opposed? Motion prevails. The language is adopted. All right, members, we're going to move on to the amendments that we have been anticipating. Let's start with A14, which addresses the language we just adopted. Chair Novotny.
Chair Latz, I
Has it
move
been
the
distributed? I'm sorry, Mr. Chair.
Chair Latz, I move the A14 amendment. This amendment amends the language to my community supervisions working group. As we just discussed on R69 through R70, it states the members of the working group do not receive compensation. It also clarifies that the working group is subject to the state's open meeting laws, and it requires the working group to consider delivery system transitions after July 1st, 2023.
And the amendments that have been proposed, they're also available in the back of the room for members of the public, correct? And online as well, where they were posted, if anyone wants to read through them. Are there any questions or discussion from members of the committee at this time on the A14 amendment? Is there anyone in the room that wishes to be heard in connection with the proposed amendment? I'm not seeing anyone. All right, Chair Novotny renews his motion to adopt the A14 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right, members, I'm just going to go in numerical order on these amendments as well. So the next item is the A15 amendment. This is domestic violence related provision changes. Chair Moeller.
Thank you, Mr. Chair. I will move the A15 amendment. This amendment amends on R74, the House language, in R75. This amendment is based on stakeholder feedback to the domestic abuse provisions, the policy provisions, where we had gone on arrivals. We had, in the original language here, it was 28 days for those arrests and misdemeanors to be, without an arrest warrant, to be open, and we've changed it and narrowed it down to 14 days. And then also, with respect to line 78.24 on the R75, we just made a cross-references to other statutes that relate to allegations of a violation of a domestic abuse no contact order or an order for protection. There were a couple of conflicting statutes, so we just made reference there.
So, Chair Moeller, the original proposal had some additional mandatory court appearance-related language in one statute, and so this amendment removes that language and simply cross-references the OFP and the HRO statutes themselves, which also have court appearance-related language in them, correct?
Yeah, that's correct. The DANCO in the OFP
I'm sorry,
language.
yes. Okay. Any discussion from members of the committee on this proposed amendment, the A15? Anyone in the room wish to be heard in connection with this proposal? All right. Seeing no one come forward, Chair Moeller renews her motion to adopt the A15 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Next item, members, the A16 amendment. And I believe we'll have Senator Limmer move the A16 amendment. Senator Limmer.
Thank you, Mr. Chair. I move the A16 amendment. It seems to be self-evident in reference to the previous Armor Task Force discussion that we had earlier. This simply adds a representative from the Minnesota State Fire Chiefs Association who would be appointed by the president of the association's board of directors.
Any discussion or questions from members of the committee? Anyone from the audience in the room wish to be heard on this? Not seeing anyone come forward. Senator Limmer renews his motion to adopt the A16 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. The A17 amendment, members. Chair Novotny.
Thank you, Chair Latz. I move the A17 amendment. This amendment replaces the language in R25 through 28 that bans the prediction market wagering with the language of the Senate File 4511 that passed the full Senate.
Chair Novotny, can you describe what changes it makes to the provisions in the side-by-side that we've adopted?
It's quite an extensive amendment, Chair.
Should we have staff describe it? Mr. Johnson.
Mr. Chair, members, what this does in this amendment form is it's removing the House language and inserting the Senate language just to make clear that it was the Senate position that was adopted. The primary difference is the first section that you see on page 1 of the amendment. This is not in the current House language. I mentioned this earlier, but this gives the Department of Aged Alcohol Gambling Enforcement Division the authority to issue cease and desist orders when they detect or identify a violation of the underlying criminal statute. The criminal provisions, which are on pages 2 through 5, are not substantially different from what is in the House position right now. There were a few very minor technical changes made in the Senate bill on the Senate floor, but because the decision was to adopt the Senate position, this is the full Senate bill, just so there was no question or confusion about that process.
Any discussion from members of the committee? Anyone in the room wish to be heard in connection with the A17 amendment? Chair Novotny renews his motion to adopt the A17 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. The A30 amendment, Representative Feist.
Thank you, Mr. Chair. This just amends the language that we just introduced regarding DOC licensing provisions. It's just a technical update requested by the Department of Corrections.
Do we need any further description from staff? Sounds pretty straightforward. Any discussion from members? Anyone in the audience wish to be heard? Representative Feist renews her motion to adopt the A30 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. The A31 amendment, Chair Novotny.
Thank you, Chair Latz. I move the A31 amendment. The A31 replaces the language of R96 related to notification of victims prior to service of a harassment restraining order. The amendment removes the 24-hour requirement. It also allows for notification immediately after service in addition to prior service of the order, and it allows notification to be done by a designee of the sheriff or law enforcement officer, such as a dispatcher.
Is there any discussion from members of the committee on the 831 amendment? Anyone in the room wish to be heard in connection with it? Not seeing anyone. Chair Novotny renews his motion to adopt the 831 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. The A32 amendment. Okay, Senator Umover Benton to move the adoption of the amendment.
Mr. Chair, yeah, I'll move the adoption of the A32 amendment. This adds in language from Senate File 3606, House File 3711. Defer to council to give a more detailed explanation.
Counsel? Or we also have a testifier from the department, Nico Bauer, who could come forward to describe it as well. Come on forward.
All right, good morning, Mr. Chair and members. My name is Nico Bauer. I'm the Government Relations Director for the Minnesota Department of Human Rights. And so the department developed the technical change before you to further clarify the process in the event of an unsuccessful settlement negotiation between parties following an investigation and determination by the Department of Human Rights. So with that, I'm happy to speak to any details or questions folks have, but that's the intent of the language.
Please tell us exactly what is being done in the amendment.
Yes, Mr. Chair, the language does three specific things. It aligns the language of the Minnesota Human Rights Act to better reflect the Court of Administrative Hearings processes, as well as reflect the Court of Administrative Hearings rebrand from the Office of Administrative Hearings to the Court of Administrative Hearings. It further clarifies the process that the Department of Human Rights would use to initiate a contested case hearing with the Court of Administrative Hearings. And finally, it removes the requirement that the hearing should occur within the county where the alleged discrimination took place. So in closing, I'll note that the bill from which this language originated, House File 3711 and Senate File 3606, are both currently on the General Register and General Orders respectively. So.
All right. And it sets a deadline for the commissioner to decide whether to forward the request for review by the Court of Administrative Hearings, right?
Correct, Mr. Chair, 30 days.
Any discussion from members of the committee? Okay. So this has gone through the committee process in both bodies.
Yes, Mr. Chair.
Anyone else in the room wish to be heard? Not seeing anyone come forward. All right, Senator Umover Benton removes her motion to adopt the A32 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Now, I understand there might be another amendment coming from a member of the House relating to clemency.
Thank you, Mr. Chair.
Chair Muller.
Thank you, Mr. Chair. I'm not offering this amendment. I just wanted to have an opportunity to have a discussion about it. This relates to the clemency provisions that the Senate heard. We did not have an opportunity to hear this in the House, and I think we had some questions or confusions, and I think there's somebody here to testify to explain it. So I can, it's drafted as the A19, but I can pass it out here so that everybody has the chance to see the language.
Please do so. And is Ms. Stark, why don't you come on forward? Ms. Stark, if you would go ahead and identify yourself and present your testimony, please.
Thank you, Mr. Chair, members of the committee. My name's Carly Stark. I'm the Executive Director of the Clemency Review Commission. The A19 amendment contains policy language that our agency brought forward in the Senate. It was heavily researched, but also finalized somewhat late in session, meaning we had approval to move forward with the legislative proposal around February and worked on trying to get hearings in March, which for those who work at the legislature know that that is somewhat late. However, we have a staff of 6, and the amount of applications we have received are growing significantly. In 2023, there were 159 applications received, and in 2025, there were 401. So this proposal creates some efficiencies and allows us to put resources in the most meritorious cases. The provisions contain, there's something related to victim confidentiality, which provides an opportunity for victims to provide a written statement that is confidential, regardless of whether they have a protection order against the applicant. That is meant to provide an opportunity for survivors in murder cases to have a confidential statement. So currently, you can only do a confidential written statement if there's a protection order, but that wouldn't have happened in those scenarios. It also allows for 3-person panels to do a pre-screening review of applications. That panel can unanimously deny the application or recommend a denial of the application without a hearing. That recommendation would go to the board, and they would decide if they agree and want to deny without a hearing, or if they want it to go through the full process, at which point they would send it back to the committee or the commission. There's also a provision that says those 3-person panels can recommend a grant without a hearing once the commission has promulgated rules outlining what offenses are eligible for that grant. There is already a provision in statute that gives the commission and board the opportunity to promulgate rules related to an expedited process for nonviolent offenses. It requires that we define what that means and what kind of notice is necessary. So this just allows those 3-person panels to be used in that scenario for those cases that are likely very, very old, nonviolent, and basically the cases that are most likely to succeed. So what we're trying to do is make it so that cases that are very unlikely to succeed can be denied without a hearing, and cases that are very likely to succeed have the opportunity to be granted without a hearing. But that would be a very defined process after the rulemaking happens. So the other provision in there allows the governor to ask that an application go directly to the board without the CRC providing a recommendation. We made sure that that includes asking for notification to the victim, prosecutors, and sentencing judges. The board would then have to hold a hearing where the applicant is present and the victim and law enforcement has an opportunity to testify. So that is for cases where there's a public interest in having it skip the CRC process. It would still have the same thorough investigation of everything else. An example of this that we ran into was there was a commutation based on health conditions. So we have to do 60 days notice to the prosecutor, sentencing judge, 30 days notice to the victims. We did that before the CRC hearing, and unfortunately the individual passed away before we were able to hear it at the CRC level. Those notification requirements would have happened still, but it would go straight to the board meeting. And then the 3 board members would have to hear from the applicant and review. The last change exempts the Board of Pardons from the open meeting requirement for waivers of the initial waiting period. So those requests are generally, if there's some kind of time-sensitive need, it's people saying, will you hear my application before I've met the 5-year waiting period for a pardon or commutation? If the board were to grant those waivers, all of the notice and hearing requirements would kick in for the pardon and commutation application. So it doesn't exempt them from any part of that process, it just allows them to apply early. Currently, the statute allows the commission to review those outside of an open meeting because some of them are more time sensitive. But then we have to wait for a meeting of the board, and the board's only required to meet twice per year. So we think the transparency to the public is still met because if it's granted, it will be part of the pardon record. And I am open for any questions. This is meant to bring more efficiency to the process and make sure that the resources are being used for the cases that need them.
Okay, so procedurally, the Senate passed these policy provisions along with an appropriation off the Senate floor. There's not a comparable House position on that. It's been sent to the Public Safety Judiciary Budget Conference Committee. Whenever that process gets rolling, anticipating we'll get targets maybe, but the commission here has stepped forward to try to separate their pure policy provisions that have no budgetary impact from the appropriations. And that's what we have in the amendment before us, which, for discussion, which also includes some additional provisions relating to victim notification that I understand Chair Mueller was working on. And so Chair Mueller, I just want to make sure the procedural background was set here. How would you like to proceed, Chair Mueller?
That's correct, Mr. Chair. I do have a couple of questions for the testifier, if I may.
Please.
Thank you, Mr. Chair. So thank you, that was really helpful. I am curious about what you mentioned for the expedited process for nonviolent offenses. Can you point me where in the language of the amendment that is?
Yes, it is on, thank you, Mr. Chair. It is on line 1.22, which says panels may be used to review requests for expedited processing of pardon applications if the commission and board adopt rules that establish objective criteria for determining which applications apply to this. So, and then our rulemaking statute specifies that it's nonviolent offenses and that we must specify what kind of notice is provided. Or we will provide notice to prosecutors, judges, and victims. So it will be basically, in the rule, we have to say, can things that don't have support go through the expedited rule process? I anticipate we will want support if there is any victim included, but this will have all of the public comment and notice periods that go along with rulemaking, which is extensive.
Chair Mueller.
Thank you, Mr. Chair. And I'm just wondering, because when I read this, I don't see a reference to those nonviolent offenses or the notice provisions. It sounds like they're somewhere else. And I think for clarity, it would be helpful to have some sort of either cross-reference to those statutes or set that out. Because the way I heard you describe it, I just don't see it in the amendment. And of course, I don't have all the underlying statutes right in front of me either to take a look. But I think something like that could be helpful if we continue to work on this amendment. And then I have one other question too. I just want to make sure, is there any, under any of these scenarios, is there any change with the victim being able to give written or oral testimony? Just want to make sure we're not taking away the opportunity to give the oral testimony if the witness, or if the victim chooses to do that.
Ms. Starr.
There are a couple places this applies, so I'm trying to point all of them out. So For that pre-screen review by the panel, there would be no testimony from the applicant nor the victim. And the pre-screen that doesn't require rulemaking, the only options are to deny without a hearing, and we intentionally do not want to have to notify the victims before that, because then they will have unnecessary stress for an application that's going to be denied. The other option for that panel proceeding would be to send it to the commission for a full hearing, which then all of the current notice provisions kick in at that point. So if there is a hearing, the victim has the right to provide confidential feedback in certain ways, in-person feedback, or written feedback. For this second part of the process, which does require rulemaking, we added that the victim would be required to provide a written statement versus coming in person, because the applicant also is not required to be there. That can be further defined in rule, but this is meant to be a process for cases that have high merit, and they likely won't have victims in most cases. I chose to have it drafted for it to require rulemaking, because I think that denying without a hearing should be used, or granting without a full hearing should be used sparingly, only in those cases where it is very apparent there has been rehabilitation, there has been time, there is no public safety risk. And I would like to have a lot of public input and stakeholder input in the rulemaking process to define that. In other states, we've seen they have their policies and statutes allow it when either there's no victim, if it's been more than 10 years and that is the only conviction on someone's record. Some of them require that there is no other violent crime on the record at all. So I think we need to take a very deep look at that, and that it's not appropriate to define it in statute, because then it can't be changed as easily.
Chair Muller.
Thank you, Mr. Chair. I still do have some anxiety about just relying on what the rule might say, especially when it comes to offenses that might involve victims. I hear you and I believe you, and I trust that you will make those changes, but if we don't put it in statute, I don't know what would happen in the future with rulemaking either. So hopefully we can maybe work these issues out as we continue to move forward. Thanks, Mr. Chair.
Mr. Chair, if I may.
Ms. Stark.
My goal in this is to make it clear in statute that we can use panels versus the entire commission in whatever expedited process is created. So if members are more comfortable taking out what the panel is allowed to do and just saying that panels may be used in the expedited process, I would be comfortable with that, or even removing lines 1.22 to 2.8.
Mr. Chair. Chair Novotny.
Thank you, Chair Latz. Repeating the concerns that Chair Muller has with this. As stated, it will come back for the separate part, for the finance part, for the budget part of the bill. We've got some time to work on this. I would suggest that we sit on this amendment right now until we get everybody comfortable and bring it back next week when we have the budget meetings.
Chair Muller, you heard you brought this forward to us today for discussion. You heard Ms. Stark's suggestion that perhaps just deleting the expedited review process, lines 1.22 to 2.8. Is that, and/or Chair Novotny, for that matter, are you comfortable with that and moving forward today? And I guess we could also ask Ms. Stark, would she prefer to do that and move forward with the rest of it today, as opposed to waiting until some or all of us reconvene with the budget bill to maybe address those concerns? Chair Moeller, Chair Novotny, what are your thoughts? Chair Moeller.
Thank you, Mr. Chair. So just to be clear, we would be removing lines 1.22 to lines 2.8. And then I wonder if nonpartisan can maybe walk us through then what the remaining language would do? Thanks.
Who would like to do that? There are no nonpartisan staff rushing to the microphone on this one. Mr. Diebel, you've got your hand on your on-off switch. Go ahead.
Mr. Chair and members, just as an initial matter, would be a conforming amendment on 1.17, which refers to the proposed deletion of paragraph D. And this would, so this would leave the panel creation in place, this three-person panel to do an initial screening of the petitions to determine their initial viability for the Clemency Review Commission, but it would remove the expedited proceeding or authority to review for expedited, and that is the part that is related to the rulemaking, I believe. So as the director indicated, it creates the panel structure for them to implement, but doesn't grant that additional authority to handle these expedited rules, which are expedited cases which are dependent upon rulemaking authority. And the director can correct me if I misstated her position.
Mr. Chair, it takes out the ability for the panels to approve a pardon without a hearing. It retains the authority to deny a pardon or commutation without a hearing or send it for a full hearing.
And either way, there'd be recommendations to the board, right? So the panel
Correct.
ultimately doesn't make the final decision.
Correct. For any of the CRC processes, the petitions then go to the board, and they can either agree with the recommendation, or they can say, no, we want this to go through the full process, or we are going to hold a hearing at the board level before we make our decision, at which point all of the notice requirements would be required before the board hearing.
Chair Moeller, your thoughts after that?
Yeah, just one other point of clarification then on line 4.9, would we need to make any changes, maybe for nonpartisan? Because we're referencing 63809 subdivision 6.
Mr. Diebel.
Yeah, Mr. Chair, and looking at this a little more closely, that does cross-reference the new section, new proposed section 1, and it relates to that. So the section 4 on page 4 would need to be deleted as well. At least, well, paragraph D for sure. We're doing this on the fly here. I'm not certain that that's the, probably needs a little more time, at least today, to process how to make this work.
Mr. Chair.
Mr. Representative Whitty also had a
Oh,
question. Chair
I'm sorry.
Moeller?
Oh, I was just going to make a comment about how we know you're in the other body, you're used to doing these kinds of things on the fly, but we're not with our amendment deadlines. So thank you.
Representative Whitty.
Thank you, Chair Latz. I think by taking some of that stuff out, it's getting at the root of your thing of trying to expand or move these cases along quicker. So I guess I'm a little confused on that. And then the question I have is at 3.25, I'm not following this correctly, maybe a little help. The governor may waive the commission hearing requirements under paragraph A. Is that the line that we're going to, the panels, or is it another section here? I guess I got confused on that one.
If I may, Mr. Chair.
Ms. Stark.
So that is a somewhat separate from the panels. That is allowing the governor to, instead of having a hearing at the commission, for their recommendation, there would be a full investigation and it would go straight to the board. All of the notice requirements are there. The applicant would appear, the victim would have the opportunity to appear, and there'd be a full hearing. That just speeds up the process a little bit in cases where it's, there's good cause to do it more quickly. But that does not relate to the panels. It just means the board will make the decision without the recommendation from the Clemency Review Commission.
So, Chair Mueller, how would you like to proceed? You brought the amendment forward for our discussion today. If we can,
Chair Latz,
Chair Novotny.
I renew my concerns about doing all this on the fly. Pretty complicated with the implications. There are several things in the bill I like. I especially like the notification on 3.14 for the victims, protections for them. But I think we need to get this right. And as I said before, we have another shot at this next week. And I'm going to recommend a no for now or pull it for now.
Chair Mueller?
Thank you, Mr. Chair. I concur. I'd like I appreciate the offer to take out some of that language, and I think we probably can work with that and come back with something when we are optimistic that we're going to have a bill that we can add this to next week. Thank you.
Right. Well, there is no formal motion before us at this time. So I think that will conclude our discussion about the A19.
Thank you for hearing the amendment. I appreciate it.
Thank you, Ms. Stark. I think if you keep working on it, there might be some path forward on this. Okay. Anything further from the House side? Chair Mueller.
Thank you, Mr. Chair. I don't know if we have an opportunity to have an amendment to the cell phone domestic violence language that we adopted. I know there was some proposal, but I'm not sure if that can be available today.
Well, we haven't adopted any final report yet, so yes, procedurally, there is an opportunity for amendment. Maybe someone could tell us what the thought is. I haven't seen any amendment, so.
So I asked the testifiers if they had a suggestion, and this was the suggested language. Any provision of Public Law 117 to 223, the Safe Connections Act, and Federal Communication Commission Rule 23 to 96 that are less restrictive than 518B03 shall apply.
Sorry, I can't hear.
So just basically a reference, I think, a reference to the federal law.
Is that written anywhere? Okay, there's an email chain I'm gonna look at. Give me just a moment. Have other members been provided with this language? Okay, can we make sure that email language gets distributed to all the members of this conference committee so that we don't just have to do it orally? On the fly, as Chair Mueller is attempting to do here? Okay. So, staff will make sure the language gets to all the members.
Mr. Chair, I have another suggestion too. It's a little clearer.
Chair Mueller.
So this would insert a subdivision that says nothing in this section supersedes or limits other remedies available to a petitioner, including any provision of, and then it names the federal law.
So is the proposed amendment that one line, Chair Mueller?
It would be, Mr. Chair. I think Vice Chair Feist has a question.
Vice Chair Feist. Sorry, I've been calling you Representative Feist the whole time. and Same with
Vice Chair.
Representative Whitty.
That's my proper title. Thank you.
Feist over there.
So, cool. So I have a question that maybe nobody here knows the answer to. But I know that we had this issue with respect to HIPAA protections, and we had a state law that required more expansive data protections around health than federal law, and then the courts misinterpreted our protections, and then we came back the next year and we introduced and passed a bill by Chair Liebling that specified that our law superseded the federal protections. And I was just wondering, however we did that, that seems like just language that we would want to maybe model here. And just randomly regarding how it's phrased here, do we want it, it's just so random, but we're doing this on the fly, so I just get to think out loud. Do we want to cite to like the name of the act, or should we do it to like 20 USC blah, blah, blah instead? I don't know. Anyway, that's my question or thought.
Well, it looks like the proposed language here does cite Public Law 117-223, the Safe Connections Act, and Federal Communications Rules. To address your last point. Does that work for you? Has the language been provided to all members in writing by email? No? Still don't? Okay, can someone please send an email to the legislators on this conference committee that contains the language so they can see it in writing?
Mr. Chair, I just wanted to point out how interesting it is for everybody in the audience watching us all look at our phones for this email. Okay. So while members are seeing the emails, which I understand have been received and folks are looking at, Mr. Carlson or Ms. Pusik, do you have anything to add at this point? You don't have to if you don't want to, but.
Mr. Chairman, I have the right to remain silent. I often lack the ability. Mr. Chairman,
Carlson.
while you were chairing and we were emailing back and forth with staff, I think the language that is being suggested that lists the public law that we're talking about to make sure that that we're not interfering with the federal law and the advice that we would give victims to go and separate from their account is adequate, and we appreciate your efforts to bring this forward. I'm house trained, so I'm used to things tying 67, 67, and I didn't know how this one was going to turn out, but as I was preparing for today, one of the things that I didn't know as the bill was moving through the Senate committee is that the federal law really doesn't require a court order for a victim to go to the wireless provider and separate from the account. And that is something that we want to make sure we preserve because it well, getting a court order is great, and if you're getting an OFP and something is already in the works, that's that can happen, but we don't need to take that step to separate if, and we want to make sure we preserve that.
Ms.
And
Busick.
thank you, Sarah Pasick, representing CTIA. In addition to how a victim can ask their wireless provider to be released from their shared plan, the federal law also provides that wireless companies have to do that within 2 days. The statute, or the proposed statute, says the end of the billing period. So that's just one other example of how the federal law, through the law, and then the extensive rulemaking that they undertook, provides some other additional, more generous isn't the right term, but better protections in these situations that they need to quickly be released. It also provides that the wireless provider won't contact the account holder until after that separation from the plan has happened, to make that very clear that they won't be tipped off that there are perhaps other actions being taken if they're taking that wireless step first or wherever that falls. So I think we just want to, or CTIA, we want to make sure that we continue to provide the best solution for victims to take and make it as seamless as possible to at least take care of this part of a bad situation.
Any questions from members of the committee to either of the testifiers about the proposed amendment? I'm not seeing any. Any members of the conference committee that have not had a chance to actually see the language now transmitted by email to all of the members? Has everyone seen it? Is there any discussion about the proposed language? Is there a motion to adopt the proposed language? Chair Moeller.
Thank you, Mr. Chair. I can move that, and I don't know if it's probably helpful for me to read exactly what it is into the record.
Yes, please do.
All right, let me just make sure this is the one. Okay, so this would be on page R96, after line 96.21, insert subdivision 11, other remedies. Nothing in this section supersedes or limits other remedies available to a petitioner, including any provision of Public Law 117-223, the Safe Connections Act, and Federal Communication Rule 23-96.
Does everyone understand the motion? Any further discussion? Chair Moeller moves adoption of that amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted.
Thank you, Mr. Chair and members.
All right. Is there any other business to come before this conference committee, or amendments or discussion before we move to final adoption of a conference committee report? No, it's Chair Moeller.
Thank you, Mr. Chair. I just wanted to mention, if anyone's looking at the side-by-side, there were a number of things that we didn't adopt today because a lot of those things passed as standalone bills, and just wanted to be sure that people understood it wasn't because we didn't like something. We are, contrary to the public narrative that we're not doing our work, we actually have passed a number of bills off of both the House and Senate floor. Thanks.
Representative Feist.
Thank you. I just wanted to make a general comment. I'm very happy to be on this conference committee, and the work that has been done has just been really detailed and collaborative and bipartisan, and I love that. And I also just wanted to express my disappointment that the reverse warrants bill that passed through the Senate was not in the conference committee report. It's an important provision protecting our Fourth Amendment rights here in Minnesota. The Supreme Court will be deciding it. The Fifth Circuit has already found reverse warrants unconstitutional. So we don't really know what the Supreme Court's going to do based on oral arguments, but I'm hoping that here in Minnesota, we can do something to address the really ubiquitous surveillance that we are all under due to these types of warrants. And I just wanted to mention that. Thank you.
Any further discussion before Chair Novotny moves adoption of the final report? I'm not seeing any. Chair Novotny.
Chair Latz, I move that the language adopted today be engrossed into the conference committee report, and the nonpartisan staff are directed to make technical and corrective changes as necessary to reflect the work of the conference committee.
Is there any further discussion on that motion? Not seeing any. All those in favor of the motion say aye. Aye. Opposed? Motion prevails. The conference committee report is adopted. Any further comments or business to come before the conference committee before we adjourn? Thank you, members, for all of your work leading up to this point, all stakeholders and folks involved in the process. Appreciate your work. We are adjourned.